I want to comment in relation to what happened in court yesterday, where the charges against one Rose Njeri were rejected by the court as not disclosing any cause of action. And pursuant to that, media houses have carried a story condemning the Director of Public Prosecution to that effect. I want to put this very, very clearly as one of the practitioners in the criminal justice system. I practice 90% in the criminal courts, and I'm well conversant with the law of the crime.
Sorry, kuna mtu simu inalia. Yeah, acha nikupepe.
The blogger Rose Njeri was charged. The court rejected that application to charge that Rose Njeri, and out of it, there has been a lot of criticism leveled against the office of the Director of Public Prosecution, or in person, the DPP himself. I'm commenting as an advocate of the High Court of Kenya, a specialist in criminal law, a practitioner in the criminal courts, and this is the true facts as it is. One, the office of the Director of Public Prosecution is created under Article 157 of the Constitution of Kenya. In Article 157(5), A, the Director of Public Prosecution can institute any matter before a criminal court in the Republic of Kenya. That mandate is exclusive to the Director of Public Prosecution. Therefore, after the police investigated, the file went to the Director of Public Prosecution. He approved the charges. Then, in Article 157(10), the Director has been given the constitutional mandate to institute those proceedings or charges without anybody giving him directions. Article 157 puts it very clearly. Article 157(10) says that the Director of Public Prosecution shall not require the consent of any person or authority for the commencement of the criminal proceedings, and in the exercise of his or her powers or functions shall not be under the direction or control of any person or authority. That provision gives the Director exclusive jurisdiction to charge or not to charge. Therefore, the Director of Public Prosecution, one Rose Njeri, did not require the authority, the consent, or direction of anybody to charge one Rose Njeri. Pursuant to those provisions, social media has put it that that is gross incompetence. I want to put it very straight. There has been no challenge in any court of law of the Cybercrime Act. What has been challenged, and the courts have declared sections of those laws unconstitutional, is one, if you look, the charges against him was that he had allegedly reprogrammed a mobile phone, which was against Section 84G of the Kenya Information and Communication Act. Section 84G, and let it be clear, is for the Kenya Information and Communication Act, which Justice Weldon Korir declared unconstitutional. There is a very clear distinction. Rose Njeri was not charged under the Kenya Information Communication Act. Equally, another judge, Justice Wilfrida Okwanyi, in her verdict, declared Section 66 unconstitutional of the Kenya Information Communication Act. The two judges have only declared sections under the Kenya Information Communication Act unconstitutional. This was put to the life and to the attention of the Director of Public Prosecution, and that is why the Director of Public Prosecution charged Rose Njeri under Section 16 of the Cybercrime Act. The Cybercrime Act has been challenged in the Supreme Court, and in the decision which I'll give the members of the press, where Justice Koome, Chief Justice, Justice Mwilu, Justice Ibrahim, Justice Wanjala, Justice Njokindungu, Justice Lenaola, Justice Ouko, all of them, when they challenge about that the Cybercrime Act was never taken to Senate, and therefore it be declared illegal and unconstitutional, the Supreme Court upheld that there is no requirement for that act to be taken to the Senate, and therefore that act is legal, it is constitutional. Pursuant to that, this similar matter was taken before in the matter of criminal appeal number E035 and E038 of 2023, Nicodemus Ndunda Makau and Joseph Musyoka Mativo versus the Republic. The judges of the Court of Appeal, that is Justice Laibuta, Justice Ocheng, and Justice Ngenye Macharia, held that in paragraph 59, having carefully considered a record of the two appeals, the ground on which they are anchored, the rival submissions of learned counsel, the cited authorities, and the law, we reach the inescapable conclusion that the consolidated appeals failed and are hereby dismissed. Consequently, the judgment of the High Court of Kenya at void by Justice Dulu J, delivered on the 30th June 2023 and is hereby upheld. It is so ordered. This is a judgment of the Court of Appeal dated the 11th day of April 2025. As we say, for now, there is no provision of the Cybercrime Act that has been declared unconstitutional, that has been declared illegal, and therefore the decision by the Director of Public Prosecution to charge Rose Njeri pursuant to the Cybercrime Act is valid, is lawful, and therefore it is not true to put a headline that the Director of Public Prosecution is not performing his work. As a practitioner of the law, the removal of the Director of Public Prosecution, if anybody has a problem, shall go before the Public Service Commission pursuant to Article 154 of Article 150, just a minute, let me confirm. Under Article 150, it is very perturbing to the members of the public to be misled that the Director of Public Prosecution, one, does not understand the law and the mandate of his office. The Director of Public Prosecution has exercised his mandate judiciously. In Article 157, sub-Article 11, the Director of Public Prosecution is supposed to hold any charges in a view to uphold the public interest. and in a manner that protects the rule of law. No evidence at all has been shown that the Director of Public Prosecution, one Mr. Rose Njeri, has overstepped his mandate or has gone beyond what the law is required. Definitely, the Director of Public Prosecution shall be moving to the High Court on Monday to challenge the decision of the lower court, because that is provided for in the law. The magistrate must have overstepped his mandate, and as you know, in a democratic country like this, Kenya, there are 4 layers. The first decision has been rendered by a magistrate in the lower court. The Director of Public Prosecution shall be moving to the High Court on Monday for revision of that decision of the magistrate. There is still the Court of Appeal, and finally, the Supreme Court. Therefore, let us not attack an office, because that office is a constitutional office. It does not have the mouthpiece to defend itself, and that is why, as a practitioner in the criminal court, have come out to defend the capacity of the Director of Public Prosecution.